You want to know the way to get better results for your clients, especially if you're a trial lawyer, litigator, defense attorney, maybe even a prosecutor, is to understand this one powerful principle in neuroscience that I have studied now for several years. And it's all about energy flowing where your focus goes. Your energy flows where your focus goes. And it's based on this one key part of our brain, which is called the reticular activating system, the RAS. And what the RAS does is it helps us to see patterns when we are focused on a particular thing. So for example, if you've ever had the experience of buying a new car, you buy a red Chrysler. All of a sudden you start to see red Chryslers, that same exact car, all over the place when you're driving around town. But before you bought the red Chrysler, you never really noticed them. All those other red Chryslers were fading off into the distance because your reticular activating system was not focused on red Chryslers. But once you buy a red Chrysler, suddenly your RAS says, hey, this car is important to you. It's important to your brain. Therefore, I'm going to help you notice all the other red Chryslers in the town that you're driving through. The same principle helps us as attorneys to obtain the results that we want. We don't always have to know how we're going to do it. So for example, when I get a new client charged with DUI, I do a lot of criminal defense, have for more than 22 years now. I talk to that person about the facts and details of the case, just like we learned in law school. But then I also start to think about what my goal is. Talking to my client about what they would like to see happen, what I would like to see happen. In the best of all worlds, what is the ideal outcome that we can arrive at? Most clients will say, I want this dismissed. I don't want a conviction on my record. I don't want to lose my driver's license. I don't want to go to jail. All those things are normal responses, but far too often, attorneys get stuck in this negative, I can't do that mode, and tell their clients, I don't think we can get this dismissed. That's not reasonable. I don't think we can go that far, but I can keep you out of jail. You're going to have a conviction on your record, but I'll keep you off probation for, I'll keep you on a shorter probation. We've all probably done this at one point or another, where our own inner doubts, worries, fears, wanting to not overpromise something gets in the way of our results in court for our clients. But when you understand the RAS and you activate that and you say to yourself, I want to get this case dismissed. I want to make sure this person doesn't go to jail. This person doesn't have a DUI conviction on their record, and this person doesn't lose their license. It's a tall order. And you don't promise anything as attorneys ethically. Sure, we don't need to promise that we can get this done, but we can say, okay, I understand your goals. I want to make that happen for you. Let's try our best. Ethically, that's totally permissible. But once you say to yourself, I want to find a way, I will find a way to get this case dismissed. I will find a way to keep this charge from entering my client's record. Your RAS kicks into gear because you've made a decision that you are going to get this charge dismissed. And then your brain starts noticing opportunities as you do your research, as you investigate, as you dig deeper, and you'll actually be more motivated to dig deeper, to do more thorough work for your client. and find yourself discovering the magic key buried in all of the facts, details, evidence of your case. But once you trigger your RAS to say to itself, to say to your brain, to say to you as a person, I'm going to get this charge dismissed, your RAS will help you discover the solution. And it might sound crazy, it might sound ridiculous, but trust me, you can go and study in neuroscience. And trust me, I'm not a neuroscientist, but I've studied this a lot, and it has tremendously impacted my practice. And I'll give you one real life example recently that I've kind of drawn on as I've shared this with you. Recently had a client charged with DUI, 0.13 blood alcohol level. It seemed like a pretty routine traffic stop for speeding, field sobriety test. There was video footage. There was some good, some bad. Some slight resistance issues between my client and the police that are never good to deal with when you're talking about getting a case dismissed. But when we initially met, I talked to her about her goals. She wanted to become a nurse. And I know it's hard to become a nurse, to get licensed if you have a conviction on your record, let alone a DUI. I've seen that firsthand. She wanted to make a better life for herself. She was young, 25 years old or so. And there was a part of me, I felt empathy, compassion for her, and realized I have this opportunity to help a young person who has never had any legal trouble before have a better, brighter future. And so that motivated me to look at all possibilities. She said, I really don't want this on my record. I know I screwed up. Okay, what can we do? So we talked, and based on her goal, charged a pretty handsome fee to help her, which I think is fair, because ultimately, as we dealt with the case, the first big challenge was her driver's license. For refusing a breathalyzer, she was going to lose it for a year. And you know what? My mind was made up. She's not going to lose her license. And my RAS kicked into gear. And we had our hearing, and there was one key fact that the police officer left out at the hearing regarding my client's license. And that one key fact that I picked up on because I was looking for opportunities to win jumped out at me, and it carried the day. The officer lost that hearing, and we won. She did not lose her license for a year. Phase 2, the actual charge, DUI. There actually were several charges: open intox, the DUI, speeding. Dug. Watched the video over and over and over again. Did more research, looking for a way to get this case dismissed. And as I dug and spent the time looking for what I knew was there, and again, this is the RAS. It will tell you there is a solution, there is an answer. You just have to keep looking. Just like with the red Chrysler, you start to notice things as you look around. You become more aware of all the red Chryslers. I became more aware of all the potential opportunities I could use in terms of evidence, case law, statutes, administrative rules, even, to get this charge dismissed. And we even had a fight over getting records that I was requesting, because I was really pushing the prosecution on getting more records from these two police officers that I believed would help. That created tension. That created frustration by the prosecutor. It created an opportunity for me, because what I did after that was file my motion to suppress evidence, file my motion to dismiss. And shortly after filing it, we hadn't even had the hearing, I get an email from the prosecuting attorney. How about we resolve this without criminal charge? There are going to be some fines, there's going to be some treatment, but at the end of the day, your client can walk away from this with a careless driving ticket. Say, that's exactly what I'm talking about. My RAS was triggered by my decision and my determination and my belief that we're going to get this charge dismissed. Actually, 2 criminal charges and 1 civil infraction charge. And we did. Were there some conditions? Sure. But is that way, way better than most attorneys find themselves in these situations when they go into a case with a negative, I don't believe it's possible idea? They just get the plea reduction to impaired or to, what everybody else is getting. And I don't know about you, but I don't really enjoy that kind of practice of law. It gets boring. It gets tedious. I'd rather really have some fun, have the legal struggle that is partially why I wanted to become an attorney. It's more fun. But when you trigger your RAS, this is what I want you to keep in mind, because I've seen this happen time and time again in my own practice. And that's not to brag, because I was not the smartest guy in law school. I was average, top third, but by no means at the very top. You don't have to be smart or intelligent or extraordinary to understand and apply this neuroscience, because it's your brain. It's science. You can look it up, verify what I'm talking about. The reticular activating system helps you find solutions that you otherwise would not find, but you have to have a firm belief that you will find them. You have to have a firm belief in order to trigger your reticular activating system that you will find a solution. And when you do, it's just a matter of time. It is just a matter of time that you will find the solution that will provide your clients with the best outcomes that really are possible, and much, much better than any attorney who's going to have a negative, doubtful, skeptical approach to handling their clients' cases. We have a duty of loyalty and to be zealous representatives of our clients. What better way than to understand the reticular activating system and apply it in your practice? Go ahead and look it up, study it some more if you need to, but trust me, having a firm decision and determination to believe that what you want in terms of an outcome, you will achieve. You don't have to know how, you just have to know that you will achieve it, and the solutions will come to you. Give this a shot. I think it will help transform your practice.